I'm going to have the privilege of giving a couple opening remarks, and then I'll turn it over to my very capable and exceptional colleague, Michael Giles, to introduce our guest speaker. We'll have some questions and answers, then we'll go from there. So with all ResCon webinars, this is being recorded, and anyone who registered will get a copy sent to them. So I think that is always the top question that comes in. The other thing that we've been able to do is we've left considerable time for questions and answers. This is going to be a very unique webinar based on the topic, but also a little bit on the approach. And so certainly use the chat, use the question and answer feature, get your questions in, because certainly Michael is an expert, and this is the time to ask the questions. And so at ResCon, as most people know, we represent the interests of residential builders who build new builds. And we do things like health and safety, we do things like labor relations, we look at technical standards, but really what we do here is we're interested in getting things built and helping our members build things. And so when you get a case like this that's very unique, it looks at the role of municipalities, and quite frankly, it looks at what didn't go right. And so this might be an extreme case, but this is a topic that we really need to dive into, because at the end of the day, we need to build more than we're building today, and we need to really examine all of the barriers that are keeping us from building. And that's kind of the goal that we have at ResCon, is to help streamline the building process, whether it's labor supply, whether it's regulations, and really make sure that builders can do what they do best, which is just build residential units, because we all know that we need more. So you didn't come here to hear me talk. So I'm going to introduce Michael Giles. He is our Director of Municipal Affairs. He is an expert when it comes to GR, and he certainly knows his way around many municipalities, including the City of Toronto. So I'll turn it over to Michael.
Thank you very much, Andrew. And I'm happy to introduce our two panelist lawyers today. I was thinking before this, Mike Foderick. Now, I met Mike over 20 years ago. And it's hard to believe. He was a law student then, and now, of course, he's at the height of the legal profession. But it was a long time ago. We've known each other for a long time. He's aged much better than me, but less worries. So Mike is with McCarthy Tétrault. He's a partner with McCarthy Tétrault. Works in municipal and planning law in Toronto. He's an expert in planning, municipal, environmental, and real estate law. He specializes in all sorts of complex developments and planning and municipal approvals. When I worked at the city, I had the opportunity to work with Mike now and again, and all I can say is everybody in the city knew that he knew his stuff, so they better come prepared. So he's an amazing lawyer. He's also on he's chair of the board of directors of Ontario Parks, and he's on the National Capital Commission. So he's a very accomplished guy, and glad he could take the time to be with us today. And Jonathan Nehmetallah, I hope I got that correct, is an associate with McCarthy Tétrault's litigation group in Toronto. He maintains a varied practice and focuses on corporate and commercial litigation, municipal and land use, professional liability, and regulatory and compliance. He's appeared before the Ontario Superior Court of Justice, Court of Appeal, Federal Court, and obviously also a very accomplished guy. I won't go too far into this because it's really what we want to do is hear from these guys. We're obviously talking today about the decision that came out of Winnipeg, in which a developer sued and basically received a judgment for about $5 million as a result of the judge determining that there was malfeasance on the part of the municipality. So obviously this was a fairly seismic decision, and has potential long-term impacts or impacts for the industry. So without further ado, I'll hand it over to Mike and Jonathan, as they certainly didn't come to hear about anything from me. Please, guys, your show, Mike.
Thank you, Michael, for the kind words. And it's nice to see you again. And I'm just looking at the list of attendees, and I'm seeing a few friendly faces on that list. So it's nice to see you again as well. I won't call you out, but you know who you are. I could say really no more about myself, other than I do primarily residential and mixed-use development in the 416, mainly towers, but some other stuff too. We work for hospitals and New York University and whatnot on the side as well, but primarily residential and mixed-use development. And I do most of the stuff for folks like Camrost and H&R REIT and Marlin Spring and others I could name. Anyway, folks know who I am. My colleague Jonathan Nehmetallah, he's relatively new to our municipal and planning group. He's been a litigator for quite a few years, and we're actually not that far apart in age, but with the cutoff is like, I'm born on the side of the line where you put on a tie when you're going to meet new people, and he's born on the side of the line where like the kids, they don't care. And that's just, anyway, strangely enough, that few year difference is somewhere that the line's in there. Anyway, I'm making fun, but in all seriousness, he's an amazing lawyer. And you'll hear from him in a second when he's going to handle the substantive sort of presentation. I'm just going to make a few overall sort of introductory remarks. And if you only take this away from it, I think some of the key themes are this, is that you're going to hear about the tort of misfeasance of public office. It's an old tort. It's something that's existed a long time, but it's relatively recently that it's been applied in the municipal context in that case in Manitoba, which you're going to hear about more today. And I know that I've heard many clients ask me over the years when they've been through one torture or another through the municipality, can we sue the city? Can we sue the city? And I've been asked that question so many times. And the answer is yes, you can. It's not something to be undertaken lightly. It's not something that should be done, carelessly. And again, we'll hear about the sorts of facts that should be present in order for that to be something you consider. But this case underscores that it's not a crazy thought all of the time. And pardon me, I have to deactivate my phone here, which is ringing as I'm speaking. I don't know how to do that automatically. And so this particular case is a feel-good case. He won a lot of money and vindication. I mean, that's not to be lost on folks here, because, we've all had situations, hideous ones, in fact, where we know we're being put through the ringer. Some of the horror stories I know some of the folks on this call have had are much greater than the horror story you're about to hear that happened in Manitoba. So I speak about vindication. It's forgive the expression, we've all been gaslit from time to time. We know we're being screwed around for years, and the municipality says, oh, this is all normal, and we're treating you fairly, and that's not true, even relative to your own experience, much less how it should work. And so this case also stands for that. And I think that's why you guys wanted to hear about it, because it's a feel-good sort of story from a developer's perspective that someone got, someone said aloud in a court decision what a lot of us think should be said more often. So again, we'll hear about the sort of facts, and I think you're going to hear us also say to be restrained, because this isn't a free-for-all that means that we can sue the city for everything every time we're delayed a little bit. That's not the takeaway you should have from this. And again, we'll see how you feel at the end, and we'll have a Q&A to talk about it. The final thing I'll sort of say, and this should always inform your thinking, because it is usually where the conversation goes when people tell me that they've made an application and the counselor's jerking them around, or the staff are saying one thing and doing another, they're just not bringing our report forward, et cetera, et cetera. They're really giving us strange conditions that, again, I'm not going to relay all the things that you guys can do as well as me. The answer in most of those cases in Ontario is we appeal to OLT. And that's a big differentiator between Ontario and most jurisdictions in North America. And it actually has relevance to the applicability of this case, because there's only so much in Ontario that you can be jerked around. It's when you let yourself be jerked around if you don't avail yourself of those appeals. And it's not a panacea appeal to OLT. It creates its own problems. It's a process, again, many folks on this call will be quite familiar with. It's not a perfect process, but it often is preferable. That imperfection is preferable to staying in limbo, staying dragged out for years. And so because you can ultimately, after a relatively short period of time, 90 days in most cases, control your own destiny in Ontario, it really does, if you're being jerked around, before we talk about suing, it's probably, we should be ruling out an appeal first, because an appeal can get you out of their jurisdiction immediately and into a fair jurisdiction, for the most part, a friendly jurisdiction for the most part. And that's often going to be the correct solution as opposed to suing. It's a longer intro than I intended. Jonathan, take it away.
Wonderful. And I do want to make clear, I think it's a very nice sweater, so I'll leave it at that. But as Mike indicated, this is a really special case, and it's a really interesting case. And I'm going to try to share my screen because I prepared, or I guess I can't, so I'll just run through it in any case. But
screen share, because we have a deck.
You can, yeah, you can now.
Can I now? Okay, wonderful. I do think it's helpful.
After, I'm sure we can circulate it after as well, but just to assist, rather than have to look at our ugly mugs. Yeah.
Yeah, it's probably a little better than that. But this is the case. It's 616-5347 Manitoba. There's another numbered company, which is the secondary plaintiff. the city of Winnipeg, together with a number of individuals that are from the planning department, four employees of the city. For simplicity, I'm going to refer to the plaintiffs in this case as the developer, and the defendant, planning, property, and development department of the city, simply as the city. And I'll provide a quick agenda of what we're going to do today. We're going to quickly go over the decision. I am going to temper your expectations. I know Mike did it already, but I think it's important to do that. I'll also go over the application in Ontario, some of the things that separate this case from Ontario, but some of the things that actually are applicable in Ontario, then followed by a concluding message and a question and answer. So a brief overview of the decision, or as brief as I can be. Keep in mind, this is a 110-page decision. So I'm doing my best here. There's two numbered companies. I'm going to collectively refer to them as GEM, G-E-M. They brought a case against 4 employees of the city of Winnipeg's planning department for misfeasance of public office. And for simplicity, as I indicated, the developer and the city. Quick facts. In 2009, the developer acquired 58 acres of land. They actually purchased the land from the city. The lands were called the Parker lands. And in exchange for the property it owned in the Fort Rouge yard area. So it was a land swap. The developer's intention in acquiring the Parker land was to develop a multifamily development called Fulton Grove. The development process was to be developer-led, secondary planning process, and that included an element of public consultation. The allegations made broadly in this case is that revolve around the conduct of 4 particular employees of the city. The urban planning department has 2 departments. One is responsible for handling development applications, and the other is responsible for secondary plan applications. And that little fact is important to know when we get into the details. This is a brief timeline. And in 2013, when this really started, the developer began working collaboratively with a planner from the plan implementation branch on a plan for the development of these Parker lands. By 2014, the city planner responsible for the development advised the developer and various city employees that the goal was to bring the development application and the secondary plan application to the City Center Community Committee, call that the committee, by November 2014 for its approval. However, by 2014, a number of issues with respect to the development process by the area councillor, John Orlikow, kind of came to light. By mid-December 2014, the developer and the city planner indicated that the secondary plan was close to the point that it could be made public. However, between February 2015 and January 2018, over the course of approximately 3 years, GEM and the city were unable to finalize that secondary plan and the development application. In January 2018 and February 2018, respectively, the developer formally submitted its secondary plan and development application. And the feedback that came, as I'm sure will be of no surprise to you all, the feedback was extensive, and it indicated that extensive changes were required and that the application could not, the applications could not proceed concurrently, the 2 applications. After 3 years of back and forth between GEM and the city, during which the city rejected the application without what's called the first reading, the city council eventually approved both applications in November of 2020, so about 7 years later. In terms of where we're at now, the city approval was contingent upon the developer and the city entering into a development agreement. And at the time the case went to trial, no development agreement had actually been completed. So you're probably asking yourself, what happened in 2013 and 2018 in that really long time period? Well, what happened was the court found that there was a pattern. I'm checking my words here, which is why I took that hesitation.
You don't have to check your words. I mean, I don't know everyone in the room, but we've all been jerked around before, and I know I speak with the sailor's tongue a little bit, but you can use the correct language, which is that they were jerked around for 5 years, or don't be shy.
So to be frank, I was going to say they were jerked around for about 5 years, but instead I was going to say on the more diplomatic. The court found a pattern of problematic behavior on behalf of the city, which I think is fairly diplomatic. And at a high level, what that means is that the actions of the chief urban planning officer and a planner from the development applications branch of the city were improperly guided by the wishes of the area councilor rather than any legitimate planning purpose. In essence, these individuals took their orders either directly or indirectly from that councilor, who sought to intentionally delay the planning process, which is really, really remarkable. The councilor in this case had an interest in slowing down the process for a number of reasons. The first of which, again, shouldn't surprise you because it's city councilor, they had a bid for re-election. That's it. It was as simple as that. The second is a bit more interesting, and I think really interesting to me because I have a large expropriation practice. The city was trying to slow down the planning approval for this property because they had actually an intention to expropriate it, and they were trying to limit density on the property, and they wanted to keep the price as low as possible. So they wanted to keep density low for the time being. So the allegation by the plaintiffs is this in a core. The developer argued that the defendants acted deliberately and unlawfully in an effort to slow down or thwart its development, and it had complete disregard for the harm that their actions were causing. This conduct, they argued, taken together amounted to misfeasance of public office. The city, though, had a response, and I'm sure it's unsurprising to all of you. They denied any evidence of intentional or unlawful conduct by any of the defendants. The defendants instead argued that the development process was slowed down by the complex nature of the development and related developments in the surrounding areas. They also argued that the development process was hampered by a significant lack of resources within the public service, which in turn caused delay. They also attributed some of the delay to changing policies within their departments, as opposed to any intention to slow down the development to the detriment of the developer. The court found otherwise, and it found in favor of the developer. The slide had just froze, so I'm not sure. There it is. As you all know, and the reason why we're here is that the court found in favor of the developer. In particular, the court found that 2 of the 4 defendants, this was the chief planner and the planner within the development application branch, it found them liable for misfeasance of public office, and it also found that the city was vicariously liable for the actions of its employees. With respect to the chief planner, the court found him liable for misfeasance on account of the following behaviors. And I would ask you to really not take each individual behavior, but really look at them as a whole and together in concert. So what the court found was that the chief planner was deliberate in slowing down the planning process. This is an incredible fact. They replaced the initial lead planner after the lead planner failed to slow down the process. There was an insistence on a peer review of the development plan prepared in consultation with the initial lead planner, and that was only done for slowing down the development process. There was explicit instructions found to slow the development process down. There was complicity in withholding information from higher ups with respect to directions improperly received from the area councilor. Failure to report concerns coming from his planners with respect to the inappropriate involvement of the area councilor, carrying out the area councilor's wishes despite those wishes being inconsistent with planning principles, knowledge that the area councilor was motivated by re-election and preventing an increase of the value of the Parker lands, and concealing of information from the developer as to area councilors' input in the process. With respect to the actual planner themselves, the court found them liable for misfeasance for the following behavior. There was an attempt to limit density in the Parker lands in order to ensure the valuation of those lands don't increase for the expropriation. Failure to decline the wishes of the councilor on matters related to expropriation, and an attempt to instead change the councilor's mind and his instructions to the planners. There was also attempts to prevent and delay the issuance of a fill permit rather than asking the developers to address any legitimate planning concerns. And finally, acting improperly and recommending that the development application be rejected. The court also took issue with a pattern of behavior that occurred between the parties during the course of the development process. Namely, that whenever an issue arose that was likely of concern to the area councilor, a meeting would follow between the members of the planning department and the councilor. Following that meeting, action would be taken that was consistent with the wishes and views of the councilor. I have a few examples, but in the interest of time, I won't go into what happened. I think you can take for granted here that what ultimately happened was they would simply have a meeting with the councilor and just in essence take their marching orders from them. The court also noted that despite internal communications suggesting that the city planners were growing uncomfortable with the orders they received from the councilor, they still continued to adhere to efforts to stymie the development process. The actions taken by 2 city planners who were found liable reflect clear attempts to delay the developer's application from being heard. So the conclusion of the case and the findings of the court. On account of those findings, the court found that the chief planning officer and a planner and the planner to be liable for public misfeasance. Other named defendants were not found liable, largely because of the fact that they were not found to have participated in this pattern of problematic behavior or found not to have any knowledge of such behavior. The court also found the city of Winnipeg vicariously liable for its employees. Ultimately, what the court found was that, while it would not attribute all the delay to the improper conduct of the members of the planning department, it estimated that had it not been for the misfeasance of the department, the plan would have likely gone to committee in the spring of 2015. So instead of a 5-year delay, there would have only been a 2-year delay. So what the court did for the damages calculation was it awarded damages based on that 5-year delay between when the plan could have been considered and when it actually was. And that was actually 2020. Sorry, I misspoke. The delay was initially 8 years. In light of these findings, what the developer was awarded from the court was what's called compensatory and exemplary damages. The amount of it was $5 million. I do note that the developer sought up to $17 million at the outset of the case. However, the court found that the information provided by the developer with respect to the losses it sustained during that 5-year delay, particularly with respect to interest accrued on loans, could not be substantiated in that high amount. But the court was satisfied with a damage award of $5 million. And part of that was it wanted to express condemnation for the city's improper conduct. It didn't, though, and this is, I think, somewhat important, the city did not award what's called putative damages. And those are damages that are strictly for the benefit of the public and to tell the city not to do this again. The damage calculation in this case was merely based on the losses suffered by the developer, losses that they could prove. So we have this big, beautiful slide. Oh, yep, go ahead.
I just want to throw on a couple footnotes there, John, if it's okay before we move on. A couple of interesting tidbits that I think people might find interesting. You know, when we look at that list of things that the court found that the planners did wrong, and I know a lot of folks are looking at that list thinking, I've been the victim of a couple of these, right? What you don't see on the list, and I don't think would probably constitute misfeasance of public office, is, you know, people are just, for lack of a better word, lazy, right? Or not very good at their job. There are planners like that. We've seen them, right? Where you think, how can this person be in charge of my application? Mere incompetence isn't enough, right? It's maybe there should be a separate tort for that, but that's not this. There's some bad faith behavior here, some intentional decisions being made to delay them. Not, I don't know what I'm doing because I'm a first-year planner who's been given this massive file. That is often what we're the victim of, and that's, again, not that isn't a sympathetic situation as well. It's just not this. Another point that I didn't hear John mention, but I think it's worth mentioning, when we talk about the counselor and how he directed them and whatnot, there were, in this case, emails that they had, which were black and white, that said, counselor, we will delay this for you. I'm slightly paraphrasing, but only slightly. We all have situations where we know counselors are putting their finger on the scale, but there is no email. It's done verbally and whatever, and they'll all deny that that's the. This case, they had the smoking gun, and so speculation isn't enough to a lawsuit. Even if you're pretty sure it's happening, you really. I don't want to say you need something in writing, but I would really be hesitant to do something unless you had a smoking gun, because you want to launch a lawsuit like this and lose. And because they had a smoking gun, they could do it with their head held high. So we don't always have a smoking gun. Here they had a smoking gun. The counselor's motivations were also relevant to consider, because the planning process in Ontario, for example, I'll use an easy example: site plan approval, something that has conventionally been. Or rezoning, better example, right? Goes to city council. It's a political decision. The councilor's allowed to have an opinion. The councilor's allowed to oppose it. Not really for the reasons of purely my reelection and just, because I want to delay it to make some local people happy, or because I want to increase or decrease the value to keep our appropriation. But it would be a legitimate thing for the councilor to still say, I don't like your development. I think it's a bad development to be voting against it or to be deferring it and whatnot. So not all counselors against you is necessarily actionable in court, right? This particular case, that it did touch a live wire, but counselors are allowed to be against your development sometimes, even if they shouldn't be, even if they're, it's personal or something like that. Not all of it's actionable. The final note I'll make, and it stood out like a sore thumb to me on the timeline, is, and it didn't end up purely factoring into the decision, but it's interesting that it didn't, was that how long the developer took to actually make the application, right? We have lots of situations where, in many municipalities now, especially post Bill 109, for those familiar with that, separate webinar, where expectations are that decisions have to be made quickly. We all see how municipalities are really, increasing the pre-application process, basically putting you through a whole application before they even want to accept your complete application, before the timelines for appeal and whatnot start. And again, there needs to be pushback on that sometimes, especially if you don't have optimism that you're going to get support right away on your proposal. If they're going to support you, of course, we dance with them the way they want us to do it. But if we think there might be friction here and they're not sure they're going to support this, it just emphasizes how get your application in, get it deemed complete. We can talk after that, city, but I'm going to insist that we get the clock started so that if I need to pull the trigger, I can appeal. And so that it's black and white that this is your delay, if there is delay, that it's not that they'll later claim, well, I didn't actually make an application. Well, it's because you told me not to, right? So I think that's something the developer probably should take more ownership of in this case than and maybe I don't know the decision as well, John. I'm not sure if that factored into the 17 versus the 5, but I do think in fairness, they probably could have acted quicker to actually insist that their application go in rather than just sort of allow themselves to be delayed by not actually making one and being lulled into a false sense of hope that maybe the city will change its tune. Anyway, those are things that stood out to me that I thought beared mentioning, John.
Yeah, and I would agree with you that those were all certainly worth mentioning. And I think one of the things, I'm going to be a bit of a buzzkill with this really ostentatious slide, but I want to temper everybody's expectations because this is a Manitoba case. And it is, like most cases that make it to trial, really fact specific. But going through how to temper your expectations, I think we can look at the takeaways here, and I'm going to highlight some of those takeaways. For starters, and kind of how Mike alluded to, and we want to note that, as we can all agree, the city's conduct in this case was particularly egregious. This is not a case where the city or its employees of the city chose albeit stubbornly, to maintain a consistent and legitimate planning position that is rooted in planning principles. This is in fact the opposite of that. The planning department's conduct in this case was clearly motivated by an improper purpose, that is the influence of the area councillor. The action or inaction, as the case may be, taken by the planning department, without a doubt, exceeded its statutory authority. Not only was the conduct deliberate and improperly motivated, it was done with an awareness that the conduct was unlawful and likely to cause injury to the developer. What this case tells us, though, is that the bar is very high to bring a case for public misfeasance. The conduct in question has to be egregious and arguably prolonged. In general, incompetence and stubbornness in maintaining a legitimate planning position is not enough to bring a claim such as this. Rather, the claimant has to show that the defendant has been made aware that the unlawful conduct would cause harm to the plaintiff. Liability does not attach to a public officer who blatantly disregards his or her official duty, but only to a public officer who, in addition, demonstrates a conscious disregard for the interests of those who will be affected by the misconduct in question. So they really have to understand that the misconduct that they're undertaking is going to harm the individual who's being harmed. In this case, it's the developer. And in this case, they knew it would harm them because they wanted to keep the property values low for the expropriation. In fact, it's important to note that not everybody or not every defendant was found liable. In fact, the reason why some named defendants were not found liable is because their conduct, while arguably incompetent, was not deliberately unlawful. A court is going to be, and this is, I think, a really large takeaway, a court is going to be reluctant to find public servants liable for misfeasance of public office, because that's the kind of liability that carries serious condemnation. And the highest court in Ontario spoke about public misfeasance and said, a direct quote, let's see if I have it up here, yes. The tort of misfeasance of public office is difficult to establish, so the plaintiff must prove more than mere negligence, mismanagement, or poor judgment. And taking a step back, I think those three things can characterize a lot of planning departments in Ontario. But to succeed, the plaintiff must demonstrate that the defendant knowingly acted illegally and in bad faith chose a course of action specifically to injure the plaintiff. And that comes from the Court of Appeal. And that case is about 10 years old now. So as I mentioned, this is a case from Manitoba. So you're probably thinking, well, what's the application to Ontario? And that's the second thing we want to discuss, which is that it's, in legal terms, it's what we call persuasive. It's not necessarily binding in Ontario, but it's certainly persuasive. That said, the misfeasance of public office and abuse of office are still valid causes of action in Ontario, so you can bring them. However, at this point in time, and I did a case law search, I'm not aware of any developer who has successfully launched an action against the city planners on the basis of public misfeasance of office or abuse of office. And that alone, I think, should tell you how kind of unique the cases are in this case. But let's talk hypothetically. Well, an action on the facts could be brought in Ontario. There are some things that stand in the way, and those things Mike alluded to a little bit earlier. First of all, as we mentioned, the bar is very high. Second of all, in Ontario, there exists some really great appeal rights under the Planning Act. So if a complete application is refused, even maliciously, a developer can then appeal and take the decision out of the city's hands by appealing to the OLT. If the developer chooses not to take advantage of that statutory exit and going to the OLT, and instead voluntarily, or rather involuntarily, voluntarily spin their wheels, that's likely to undermine a claim like this. In other words, if you have another option and you choose not to take it, the court will not look favorably on your position. That said, in the case we're discussing today, much of the misfeasance alleged is alleged to have occurred prior to the completed applications having been rejected. So in Manitoba, from my understanding of the law there, they don't have those appeal rights that we have here. So the big takeaways are: understand that the bar is high, understand that at least in Ontario you have appeal rights, and by virtue of those appeal rights and other statutorily available exits, you should take advantage of those exits where available.
I would say one thing on a final note, if I might.
Please.
You know, when Michael Giles reached out and said, we'd like you to do a presentation on this case, I really thought that this was the punchline, right? It's like, you know, if, you know, they're just, you can't jerk us around that much in Ontario, because we can appeal to OLT where the city's opinion is only one voice in the room. It's not the final say anymore. And so you know, I was really intending, I think, to come here and sort of discourage folks from thinking that they could bring a claim. And I think that's still good advice because the bar is quite high. However, as I read the case through and as I really compared it to some of the facts just on the files that I've been involved with, and I'm sure I have not personally experienced the worst horror stories out there, I don't think it's a crazy idea to bring the claim in Ontario. I'll just say it. I think you don't have the right facts. You would want a particularly egregious case. Ideally, you have that smoking gun, like the one I talked about earlier. But with the right facts, the right case, I'd give it a try. I think you want, and especially the first person to try it. I'm sure a lot of folks are thinking about it, and they're you know, thinking about them having been delayed longer and worse. I mean, we all have stories that I think are fairly worse than the one that John outlined. If you've been developing for more than 5 years, you probably do. And, you know, I think the first person who tries it, really, I hope they bring a good set of facts. I hope they don't come with a weak case and then it gets thrown out and then this is a dead issue in Ontario. I hope that whoever does get something that there is misfeasance found, and that so we can confirm that, yes, it is possible. And maybe it's something that I'm not that excited about the idea of many developers suing and getting money, but I am interested in the idea that you know, planners and other bureaucrats across Ontario sort of sitting up straight in their chair and thinking, you know, maybe we have to treat people fairly, or else there could be personal consequences, which right now most of them don't feel that way. I think that would be, forgive the expression, but the chill that might put across appropriately, right? Right now there's too many folks out there in municipalities. Again, many of the actors we heard Jonathan outline basically treat it like, oh, it's not my money, who cares? It's all a big game, you know, we'll delay them and it's, you know, no consequences to me personally, it's all a big joke. It's not a joke. This is serious stuff. We're dealing not just with developers' money, but we're dealing with people's homes, which are delayed, and all sorts of other bad, you know, parks that are delayed, and all the community benefits that are delayed, and all sorts of things. And that there's sometimes it feels like, I think it's true that there doesn't need to be care about that. And so it would be nice if a couple of cases like this sort of cause them to think twice about just delaying things wantonly. And so I hope someone does bring that case. I'm not sure we're keen to go find that plaintiff, but if the right facts came along, I mean, McCarthy's is, you know, forgive me for saying so, often regarded as the best litigation firm in Canada. We wouldn't be afraid to, if the right facts were there, but we would discourage anyone who was a mediocre case. It would have to be a pretty good one, and for all of our sake. I'll leave it there. John, any closing thoughts from you?
No, I was going to make a pitch for myself as a municipal litigator is what I was going to do, and say if you do think, having regard to Mike's cautionary statement, if you do think you have something, why not come chat with us?
I have a couple files where I've thought maybe it's not crazy, but I'm not, you know, anyway, if you have specific facts we like to talk about, but the bar is high. The bar is high.
Absolutely. And I do want to thank everybody. I know there was a lot there, but if anything, hopefully we'll put a bow on it at the end for all of you. And I think we're happy to take questions as well.
Perfect. Thank you very much. So we did have a few questions come in during the registration process. So if I'm a builder and I know I have a good case and I know the bar is really high, but let's say I have a good case, what if I'm afraid from retribution, like from the municipalities to come back and cause certain other delays, like maybe delayed lane closures or anything like that? What would you say to a builder who's just afraid to take legal action because of that?
If I'll take a first stab at it, John, if you don't mind. What they did in this case, they waited till the end, right? Not just because it reduced the possibilities that they could, you know, be vengeance took on them, right? but also because you quantify the damages. We don't know the full extent of the delay. If they're not supposed to be jerking around you with the lane closures either for these reasons, right? And so let's get to the end of the project, you know, take a deep breath where we're not at risk, or we're not putting our project at risk, and then we'll launch the claim, right? That's probably the right advice, because although, you know, we give a lot of advice in-house to municipalities. It's not a kind of line of work that we look to get into, but some of the bigger municipalities in the GTA, from time to time, we've been their in-house, their outside counsel. We get consulted when they get sued by someone in a novel way and they don't have the wherewithal to deal with it within their in-house legal team. They call us in. And without telling specific sort of tales out of school, you know, sometimes the claim has the opposite effect. Sometimes the claim, and I can think of one example, I'm really tempted to explain it, but it'd probably be inappropriate, so I won't, where the claim caused the municipality to say, geez, we don't want any part of this. Just, you know, it had the opposite effect that you just described. It was like, let's just get this done. Even we'll hold our nose on a few things. And that's what they want, how they wanted to handle it, because they didn't want to have the publicity and whatnot. So it's not a guarantee that they will take vengeance. Sometimes it could be a neutral, or it could be the opposite effect. But I think the safest bet is to wait until the very end. And I know what you're going to ask. The follow-up questions, obviously, well, I have another project coming, and what of that? And listen, I'd be lying to you if I said that that's not a consideration, but I wouldn't let that deter me. Again, I know something about how municipalities work in terms of not just from the legal perspective, but from sort of how their brains work. And it's really tough for a grudge held by one person to translate into all the activities of the city, especially if you're saying like the city of Toronto. One planner having a grudge against you, or even one councillor, can't stop you from getting your building permit, can't stop you from getting your lane closure. Even the mayor themselves doesn't have that. So in a smaller municipality, it's a bit more tight knit, but even then, like, there are other statutory remedies. So I wouldn't let that deter me alone. In general terms, a specific site, specific case, specific we could talk about, but I wouldn't call that a non-starter reason not to pursue it.
Okay.
John, would you add anything, or did I more or less?
No, I think you nailed it. I think that's exactly it. Like, I don't, so listen, I teach damages at the University of Windsor in the law school. And so I'm always thinking about how do you kind of quantify and get everything together for the end of a case. And in this one, and the thing to always keep in mind is that you always have the obligation to mitigate your damages. And I think what Mike was talking about, and what that leads into, is that you should be working to complete the application and get everything done you can. And so I think that necessarily stops you from bringing it early, bringing the application early. And I would caution against bringing it early, and you can always look backwards and quantify your losses. And I think the other thing to remember is that it's sometimes well, I think Mike's last point is exactly it, and I would leave it at that. I think it's, you know, these cities are often very big places, and while one person may have a grudge, it may be difficult for it to filter through the bureaucracy.
Yeah.
It's hard enough for legitimate work to filter through the bureaucracy, let alone grudges.
Yeah, makes sense. And then, Michael, you spoke about the smoking gun. They kind of had this, like, you know, like clear email sent saying, I will, you know, delay this for you. So if I want to come with this case as a builder, I need to have a bunch of evidence coming in, I assume. But how do I get the smoking gun? Like, was the smoking gun found as they investigated, or?
That's a great question. And John can speak to, when you sue someone, the discovery process. I think folks on the line here, again, some of the names I see are sophisticated business people outside of the development world. So when I mentioned that the discovery processes, again, I think people understand, because they've been in lawsuits not development related, where they understand that you can get disclosure of things. But one tool that people don't use a lot, and I found it super useful even in when we're not even thinking about suing anyone and we're just doing planning applications, whether they're delayed or not, freedom of information requests. They're $5, generally speaking, $10 in some places. And they take an awful lot of time to be processed, and they give you a big song and dance about what's excluded and not. But in the few cases where I've been desperate to see what the city's files say, and I won't, this isn't a class on freedom of information where I'll be, MFIPA, where I can talk about what they won't disclose everything to you, but you get all kinds of things out of that process that might surprise you, not just for litigation reasons, but might open your eyes to emails back and forth where staff say, oh, we consider this, but not that. you never mentioned that you consider this, right? Like it just, wow. And I had one, not going to tell war stories, but there is one case where we did a big FOI request, and it was just an OLT case, mind you, but all kinds of smoking guns came out of it, and we settled on our terms because we had them dead to rights all over the place with the FOI request. So it's sometimes the amount of time they take to get back to you doesn't really align. Well, if you're going to the hearing or you have more results in the next 60 days, probably an FOI is not going to get done that quick in most cases. But if you have 6 months to play with, throw in the $5, see if anything comes back. It's not a waste of your $5 to give that a try. You might be surprised. And a final point is that when you have the FOI coordinator reach out to the counselor, the planner, and say, FYI, there's an FOI request that's come in, give me all of your emails that relate to this topic, that can sometimes cause them to stand up straight. Okay, I better watch my P's and Q's on this one. I better not be, spiteful or something, because someone's going to say something if they catch me doing something, right? And normally no one watching me. So I'm saying FOI is a consideration. I'm saying the disclosure/discovery process. John, would you add to that, or?
The only thing I would add is that if you are bringing the claim, be cautious about how you're bringing the claim, because if you bring an action, you are given these wide-ranging discovery rights that Mike had indicated. And under the rules of civil procedure, all parties need to produce any document that's arguably relevant, and question of relevancy is really broad.
Yeah.
If you bring in what's called an application, which is a more narrow claim, which I think some people would be tempted to bring because you can move faster with an application, you don't have those same discovery rights. And that's something that I think if you do the FOI request and you find, oh my God, there's something here, I want to sue the city or bring an action against the city. I think when you're coming up with the strategy and moving forward for litigation, you should have somebody who's not just kind of knowledgeable about the intricacies of the planning application and what you need to undertake and what's the time expected and how a reasonable actor is supposed to act in that process. You should also be putting thought towards your litigation strategy and how you undertake that litigation strategy, understanding that you probably want some wide-ranging discovery rights, and understanding that you probably want a litigator or at least a litigation team that's going to understand how these planning processes work.
Yeah. So I know you said that just because one person could be bitter, it doesn't, translate within the whole municipality. But what do you think other municipalities can learn from this? And is there something that they would be changing or taking care of, just in case they would potentially get sued too? What do you think of that?
I'll try that first, John.
The lessons from the city. I think one of the more important lessons is understanding kind of the appropriate roles of everybody and making sure your staff understands the appropriate role of elected officials. Because, I can appreciate an elected official overstepping sometimes, an overzealous elected official, not fully appreciating kind of what they can say and what they can't say during these processes. So I think proper training for staff and elected officials is really important. I also think having, at the end of the day, I act for developers, and that is kind of my preference, and I'm always looking out for their best interests. But I think if I was a city, I would be trying to design more streamlined processes and more clearly understood processes with clear expectations for all parties involved, so that applications can't get off the rails like what happened here. And I suspect a lot of it. Yeah, please, Mike.
Oh, no, sorry. I didn't mean to cut you off. You finished your thought.
Well, I think a lot of the problems that happened here could have been ameliorated had there been proper training in place for the staff, because the staff could have listened to the counselor and said, okay, thanks, and then gone on their way. And instead they took direction from an elected official, an improper direction. So I think training goes a long way. If
I was a city solicitor for a municipality, and I've been offered that before and I've said no, but if I was giving them advice, their planners and their lawyers in-house, about how to handle these, I would say two things. One, you don't have to jump when the counselor says how high. Work with them, talk to them. Michael Giles can speak a lot more articulately than I can. He's been doing that a lot longer than I ever had exposure to it, in terms of how hard it can be to say no to a really important counselor. It can be really tough. Let's not understate that. But you have to have a backbone, and you can't let your junior staff sort of be at their mercy. You have to stand up to them sometimes in a friendly, diplomatic, and all that political stuff that the staff are involved in, but they have to, you can't just say, no, counselor, take a hike. You have to do it in a more diplomatic way, but you ultimately can't be at their mercy. Even if they're a super popular counselor, strong personality, you have to sort of know where those boundaries are. The second point is that, and I think this is good advice in general, but especially if you're a municipality, you can't take stuff personally. We're going to win some, we're going to lose some, but the minute you start adding spite and those sorts of considerations into your decision making, you're really not just you're a bad civil servant at that point, but you're exposing yourself to litigation now because you got dirty hands, you got bad faith. If you're, as I think this case demonstrates, even if you're not that good at your job and if you're not that smart or experienced, that's not really actionable. That's kind of all, even I think we would agree, morally speaking, forgivable on some level. It's understandable. But when they get that, we're going to twist the knife and that's where you start to cross the red line. And so I'd advise everyone, even if you feel strongly about an application, take a deep breath. Don't take it personally, right? Doesn't mean you let stuff go easy, but it does mean that you have to know where your boundaries are and don't let it cross that line, or you're putting yourself at risk if you do. I think that's the advice I'd give in-house planners if I was their lawyer.
So this is specific to delays, but do you think that we could see further litigation and other sorts of issues related to the housing sector, like, for example, green standard requirements or inclusionary zoning or any of that stuff?
I'm curious about that question. It's because inclusionary zoning. Do you mean the delay in approving the PMTSAs by the Municipal Affairs? Is that what that means, or is there another type of delay with IZ that they're referring to?
I'm gonna let Michael answer that.
I think it was generally speaking about whether they could try to use the legal process to get out of inclusionary zone.
Oh, I see. Well, what an interesting question. I'll take this as an opportunity to make a plug. The Municipal Affairs is currently considering 120 something PMTSAs, protected major transit station areas, that it's sitting on its desk, and some of them have been sitting there for almost 2 years, some less, but they're still there. And without getting into it, they're not been approved as of today. And the transition provisions in the city's bylaw, if we're talking about the City of Toronto, says that as long as you make a complete application for site plan approval prior to those PMTSAs coming into force, is your grandfather. I'm paraphrasing, but that's a fair paraphrasing. So if you are worried about IZ because you're within a PMTSA, there's technically still time to get yourself exempted if you're in Toronto. Again, I'm not going to go through every municipality. I'll think a lot of folks here are Toronto-based. So don't fret about it. Act quickly. And people, I've talked to folks 6 months ago who said, I've missed my chance. They're going to bring these PMTSAs in any minute. They haven't yet. So you need to make a site plan sooner or later. Get one in now. That's what I'm doing. I mean, all of my clients, we have lots of towers. I have 30 towers or something. We have on the go, probably more. Everywhere we can do, we're grandfathering ourselves from IZ. We're just trying to corrode through. And there was a provincial transition, which was separate filing plans of subdivision. I guess that's closed now, but we did that with every application we had. Get yourself exempted. Let's talk about IZ after it's in force and you have to deal with it. For now, the best advice, get yourself exempted if you still can, and there may still be time if you haven't done it yet. That's my best advice on IZ. You'd rather not be subject to it is the safest way to deal with IZ. You are subject to it, then we'll talk about that, how to triage it. But let's get yourself exempted is my advice.
Okay. So for our last question, we know that this happened in Manitoba. We know how it would somewhat apply to Ontario. How about Quebec? Given that they just have like a completely different legal system, what would happen in Quebec?
The short answer is I don't know. I'm unfortunately not a civil lawyer.
Yeah, from the developer's perspective, we're very Ontario based.
Yeah.
After Ontario based, we don't speak out of turn about other provinces when we're not sure. But I can tell you Quebec is a very different system, and from a developer's perspective, not a better system. I know a little bit about how their system works, and we have nothing to envy in Ontario. Like, we're better shape than they are, even at our worst. The developers don't control the process the way we can sometimes control it here. So if you want a more detailed answer on that, I would have my colleagues from our Quebec or Montreal office chat with you, but we wouldn't speak out of turn about things that are outside of our jurisdiction.
Yeah, I understand.
The answer is we'd need another webinar, is what you're saying. So
can do one, sure. There's lots of topics that you'd be interested in. You know, we're giving away a lot of, we have colleagues who are experts on the HST, GST stuff and the consequences for residents. If you want like a webinar on that, I have one of my colleagues who'd be keen to give one. I'm having him do lunch and learns for a number of our clients in-house, and you know, so we could easily do one for you. There's other topics I can think of, but that's one of a lot of our
I can think, I'm going to be at the Supreme Court in a couple months on constructive expropriations. So I think that's that's a really interesting topic as well. Basically, when the city
expropriate you, but they take actions which are tantamount to expropriation, and they should pay you for that anyway. Because
that's exactly what I'll be arguing.
Exactly, that's an interesting area as well, for sure. Anyway, we're really grateful for the chance to talk to you guys, and again, a lot of friendly faces I'm seeing on the list. So, and Michael Giles is the friendliest of all. So, really happy to come back anytime you think there's something useful to hear from us on.
Well,
Perfect.
great. And I'll just maybe close out with thanking both of you very much. It added a lot of perspective to this. Sort of at the beginning, it was like, great, everybody goes soon. Now you're like, oh, maybe not. But we'll see. With everything, it can be very complicated. So I wanted to thank you on behalf of everyone for appearing, and we'll certainly look at some of the other webinars. Just a reminder to everyone, we have our housing summit on October 12th, and you can go to our website, rescon.com, to register for that. There's some interesting panelists, the mayor of Toronto and a few others, and it's going to be an interesting day. But again, thank you very much to Mike and Jonathan. I really appreciate it, and we all appreciate it. It's very insightful. Thanks very much. Have a great day, everyone.
Good day, everyone.
Thank you.